Welcome to Into the Margins, where we explore the stories, strategies, and decisions behind profitable businesses to inspire the next generation of entrepreneurs. I'm Al Donovan, editor at Into the Margins.
And I'm Allison Bennett, business journalist at Into the Margins.
So today we are doing a deep dive into something that, well, I think a lot of founders just kind of treat as a boring checkbox on a tax form.
Oh, completely. I mean, everybody wants to get to the fun part, right? The branding, the product launches, the marketing.
Exactly. Nobody wakes up and says, I can't wait to figure out my corporate liability structure.
Right, but it is literally the invisible architecture of your business. And if you get it wrong, it can act like a ticking time bomb.
Which is terrifying, because if you start a business with your best friend tomorrow, and you guys just start splitting the ad revenue, you've actually just formed a general partnership by default.
You have, without signing a single piece of paper.
And if that friend, say, accidentally infringes on a copyright or signs a terrible vendor contract, you could legally lose your house.
Yep. Your house, your car, your personal savings, all of it is exposed.
So that's the mission of this deep dive. Whether you're listening to this while packing orders in your living room or maybe sketching out wireframes for a sauce product, we want to decode these structures.
Because getting this legal framework right early on is the ultimate shortcut. It dictates how you're taxed, your personal liability, and, your ceiling for growth.
Right. So let's start with the absolute basics. The default state.
The path of least resistance.
Yes, the sole proprietorship. I mean, statistically, something like 70% of businesses in the U.S. are sole proprietorships. It is massively popular.
Because it's completely frictionless. There are no state filing fees just to exist, no complex corporate tax returns. You just start selling.
And the taxation is incredibly simple. It's called pass-through taxation, meaning the business itself doesn't pay taxes.
Right. All the revenue and expenses just flow directly onto your personal tax return. So it's cheap, it's easy, and you have total control.
Which sounds great. But there is a massive hidden trap here, right?
The biggest trap. And that is unlimited personal liability.
Okay, unpack that for me. What does that actually look like in the real world?
Well, in the eyes of the law, a sole proprietorship is not a distinct legal entity. There is zero separation between you, the human being, and your business.
So the business is just me doing stuff.
Exactly. You are the business. So let's say you take out a business loan and things go south. You can't pay it back.
Right.
The bank doesn't just look at your empty business account and say, oh, well, better luck next time. They cross the line right into your personal life.
Because there is no line.
Exactly. There's no firewall. Or worse, say a vendor slips on a wet floor in your workspace and sues for medical damages. They are suing you personally.
Wow.
Yeah, your personal checking account, your retirement fund, it's all legally on the table to settle that lawsuit.
I always kind of compare it to driving a sports car without a seatbelt. Sure, it's fast and easy, but you are incredibly vulnerable if you hit a bump.
That's a perfect analogy. And honestly, it's scary enough if you're a solo founder. But the anxiety multiplies exponentially the second you bring a partner into the mix.
Right, the general partnership.
Yeah.
Because now you aren't just responsible for your own mistakes.
No, you are playing financial roulette with someone else's judgment.
So on paper, partnerships look great. You pool your capital, you share the workload, you keep that easy pass-through taxation.
But the legal mechanism underneath it is called joint and several liability. And this is where so many founders misunderstand the risks.
Let's clarify that.
Yeah.
Because joint and several liability does not mean I am responsible for 50% of the debt.
Right. Far from it.
Yeah.
It means every individual partner is independently responsible for 100% of the business's debts.
Wait, really? 100%?
Yep. Let's say you and I have a general partnership. I go rogue and sign a terrible, super expensive contract without telling you. We get sued. If my bank account is empty, the court doesn't care that I was the one who signed it. The creditor can look directly at your personal savings and legally take everything you own.
Just to satisfy a debt that you created.
Exactly. You are legally tethered to my mistakes.
That is a genuinely chilling reality. If the risk is literally losing your family home over a partner's mistake, why not immediately set up a protected corporate structure?
Cost aversion, mostly. Setting up a formal corporation costs money. You have annual compliance, state fees. People convince themselves they're too small for it.
We're just testing the waters, that kind of thing.
Exactly. But if you are going to operate in that exposed state, you absolutely need a rock-solid partnership agreement.
Though, to be clear, a partnership agreement doesn't actually protect you from the outside world.
Not at all. It only dictates the internal rules, like how profits are split, who makes decisions, or how a buyout works.
Right. It manages the relationship between the partners.
Right. If a third party sues you, they do not care about your internal agreement. The unlimited personal liability is still there.
So eventually, founders hit this point where they realize the personal risk is just unsustainable. They need a shield.
And historically, they were kind of stuck. You either accepted the massive risk of a partnership or you formed a corporation.
But corporations come with insane formalities and terrible tax burdens.
Exactly. There was no middle ground. Until 1977, actually, when Wyoming passed the very first state law creating the limited liability company, or the LLC.
And the LLC completely changed the game. I mean, we always hear it described as the best of both worlds.
Because it is. It's a synthetic structure. It gives you the heavy-duty legal safeguards of a corporation, but it preserves the frictionless operational ease of a sole proprietorship.
Let's break down the mechanics of that shield, because it's not just a piece of paper. When you file your articles of organization, you're essentially giving birth to a new legal person.
Right. That is the core mechanism. It's called the corporate veil. The LLC, not you, enters into the contracts. The LLC takes on the debt.
So I am just a member who happens to own the LLC.
Exactly. The LLC absorbs the risk. If the business goes completely bankrupt, creditors can liquidate the business assets, but they hit a brick wall when they try to touch your personal stuff.
Your house is walled off behind that veil.
Yes, but, and this is a massive but, that veil is only strong if you actually maintain the separation.
Right, piercing the corporate veil. I've heard horror stories of founders setting up an LLC thinking they're invincible and then totally destroying their own shield.
It happens all the time. The legal system demands that you treat the entity with respect.
So what does that look like? Mixing funds.
Basically, yeah. If you use the business debit card to buy your personal groceries or pay your home electric bill, a judge is going to look at that and say, this isn't a real separate business.
This is just an alter ego.
Exactly. And with the stroke of a pen, they tear the veil down. Suddenly, your personal assets are completely exposed again.
So the absolute golden rule is separation of church and state.
100%. Separate bank account, separate accounting. When you sign a contract, you sign it as a representative of the LLC, not as an individual.
But aside from the defensive benefits, there's a big offensive advantage to an LLC, which is credibility.
Oh, the perception shift is huge.
Well,
When you pitch a massive corporate client, operating as an LLC signals that you are a formalized professional entity.
you aren't just doing this out of your garage on weekends.
Right. But honestly, while the liability shield and the credibility are great, a lot of financial advisors push people toward LLCs for the tax mechanics.
The tax toggle switch. I absolutely love this concept. Let's dig into this.
It's so clever. By default, the IRS doesn't actually have a specific tax bracket for an LLC.
They just look at it and say, what do you want to be?
Basically, if you're a single-member LLC, the IRS treats you as a disregarded entity, so they tax you exactly like a sole proprietor.
The profits pass straight through to your personal return. So you get the legal shield of a corporation, but your taxes stay incredibly simple.
Right. But let's say your business takes off, you're making serious money. Suddenly, that path through taxation hurts because you are paying hefty self-employment taxes on all of your profits.
And this is where the toggle switch comes into play.
Exactly. The LLC structure allows you to file a form with the IRS and elect to be taxed as an S corporation.
Without having to dissolve the LLC and start a new company.
Exactly. The LLC itself stays exactly the same. You're just changing the wiring that reports to the IRS.
Okay, so why does electing S-Corp taxation save you money?
Because it allows you to split your income. You can pay yourself a reasonable salary and take the rest as owner distributions. And distributions aren't subject to self-employment taxes.
Oh, wow. So for a highly profitable small business, that can save you tens of thousands of dollars.
It's a brilliant strategy.
But wait, if the LLC gives you a bulletproof shield, professional credibility, and this incredibly adaptive tax toggle switch, why leave?
Right. Why not just stay an LLC forever?
Yeah, at what point does a founder hit a wall and realize the LLC is actually choking their growth?
That wall usually appears the exact second you decide you want to build a unicorn.
Venture capital.
Exactly. If you want to stay mid-sized, bootstrap, and keep tight control, an LLC is perfect. But the moment you need to raise $10 million from a VC firm, the LLC completely fractures.
Let's talk about why it breaks down, because this is fascinating. Venture capital firms are usually structured as complex partnerships themselves, right?
Yes. So if they invest in a pass-through entity like an LLC, your startup's tax liabilities would pass through onto the VC's tax returns.
And then that passes through to their limited partners.
Which is an absolute accounting nightmare for them. Institutional investors simply will not deal with it.
So they demand a structure that cleanly traps the tax liability inside the company itself.
Yes, and that brings us to the heavy machinery, the C corporation.
The gold standard for massive scale.
The law treats a C corp not just as a separate entity, but as a completely distinct legal person, totally disconnected from the founders.
Okay, but, and I really need to push you on this, treating the corporation as a literal person introduces the most notorious drawback in all of business law.
Double taxation.
Yes. If a C corp hits you with double taxation, why would any rational entrepreneur ever voluntarily choose to do it?
It sounds crazy, right? But let's look at the mechanics of double taxation first.
Right.
Because the C Corp is its own person, it files its own tax return and pays corporate taxes on its profits. That is layer one.
Right.
Then, if the corporation wants to distribute those remaining profits to the human founders as dividends, the IRS views that as a second, completely new transfer of wealth.
So the founders pay personal income tax on those dividends.
Exactly. The exact same dollar of profit gets taxed twice.
Which is mechanically devastating to your profit margins, not to mention the intense operational friction.
Oh, it's huge. You can't just make a business decision at the kitchen table anymore.
Right. You are legally mandated to have a formal board of directors. You have to hold annual shareholder meetings. You have to record official corporate minutes.
And if you fail to do that compliance dance, the state can pierce your corporate veil.
So naturally, founders hear all this, they hear double taxation, and they desperately look for an escape hatch.
And Congress actually created one, the S Corporation.
Right. Now, an S Corp is structurally a corporation, but it carries a special tax designation, so it pays no federal income tax at the corporate level.
It borrows that pass-through taxation mechanism from the LLC, bypassing double taxation entirely.
So a founder looks at that and thinks, amazing, I get the prestige of a corporation, I bypass double taxation, I'll just use an S Corp to raise venture capital.
But this is where the mechanics hit a brick wall. The IRS didn't just give away that tax loophole for free.
Right, the S Corp comes with some pretty draconian restrictions.
Huge restrictions. First off, you are legally capped at 100 shareholders. And every single one of them must be a U.S. citizen or a resident alien.
Which means you cannot have another corporation or a partnership own shares in an S Corp.
Which immediately disqualifies almost all institutional money. VCs are legally barred from holding shares in an S Corp without destroying its tax status.
But even if you somehow found a workaround for the ownership rules, there is an even bigger flaw for scaling startups.
The stock classes. An S Corp strictly mandates that you can only issue one single class of stock.
Meaning every single share has the exact same voting power and financial rights.
Right. If you hold one share and I hold one share, we are absolute equals.
And let me guess, venture capitalists do not want to be your equal.
Never. If a VC hands you $20 million, they demand preferred stock.
What does that actually mean for the founders?
It means they want super voting rights to control the board. And they demand liquidation preferences, meaning if the company gets sold, the preferred shareholders get their money back before the common shareholders, like the founders and employees, see a single dime.
Wow. And you just mathematically cannot structure those complex investor demands within an S Corp.
You can't. And that perfectly answers your earlier question about why anyone would ever accept the double taxation of a C Corp.
Because the C Corp allows for unlimited classes of stock.
Exactly. You can have common stock for the employees, Series A preferred for early investors, Series B for later investors. It is the only legal vehicle capable of handling that kind of sophisticated financial engineering.
Especially if you set it up in Delaware, which is pretty much the VC standard because of their highly developed corporate court system.
Right. So double taxation isn't some rookie mistake founders make. It is literally just the price of admission.
If your goal is to raise institutional capital, issue complex equity, and eventually IPO, the C Corp is mandatory.
Completely mandatory. But let's bring this back down to earth for a second.
Yeah, because we've covered a massive spectrum here, from the seatbelt list sole proprietorship all the way to the rigid machinery of a Delaware C Corp.
Right, and the listener is probably sitting there thinking, okay, but how do I actually filter this for my own business?
Well, you can distill this entire landscape down into a framework of 4 critical pillars. Whenever you evaluate a legal structure, you just run your business model through these 4 factors.
Let's do it. Pillar 1, taxation.
Right. Where does the tax burden fall? Do you need the simplicity of pass-through taxation? Or are you willing to take the hit of double taxation because you plan on reinvesting all your profits back into growth rather than taking personal dividends?
Exactly. Pillar 2 is liability. Is your personal house at risk? And how dangerous is your actual operation?
Yeah, a freelance copywriter has a totally different liability profile than a company operating a fleet of delivery trucks.
Exactly. Pillar 3, capital. How are you funding this machine? If you're bootstrapping, an LLC is incredibly efficient. If you need equity from VC firms, you are pointing straight at a C Corp.
And the final pillar, compliance.
Hmm.
What is your tolerance for administrative overhead?
Right. Are you ready to hold mandated board meetings and record official minutes? Or do you need the operational agility of an LLC, where you can make a major decision via a quick text message to your partner?
Taxation, liability, capital, compliance. If you analyze your vision against those four, the right path usually becomes glaringly obvious.
But there's an ultimate trap here, and it catches even brilliant founders.
Oh, the timeline trap.
Yes. They run that four-pillar analysis based entirely on what their business looks like today.
Right. I'm operating out of my garage today, so sole proprietorship makes sense.
Exactly. But building a business is an active projection. You can't make structural decisions based on the present. You have to plan for your 5-year vision.
Because unwinding a legal mistake later is agonizingly expensive.
Oh, it's brutal. Let's say you start as a messy general partnership because it was free. 3 years later, you have real revenue, massive liability, and you finally want to bring in an investor.
You have to hire lawyers, draft complex transfer agreements, deal with tax hits from moving assets.
Untangle years of commingled funds just to convert into a clean C Corp.
It is the ultimate measure twice, cut once scenario. Doing it right in year 1 might cost you $1,000 in legal fees. Trying to fix it in year 3 will cost you tens of thousands.
Not to mention scaring off investors who take one look at your messy cap table and run away.
Which is exactly why this is the stage where you absolutely must consult a specialized business attorney or a CPA.
You have to. The nuances of state law require expert navigation. You need someone to look at your specific industry risks and ensure your legal architecture actually supports that 5-year vision.
And as we wrap this deep dive up, I think there's a broader philosophical point about how founders view this infrastructure.
I agree, and I want to leave the listener with a final thought to mull over. We just talked a lot about building for that 5-year vision.
Right.
But what happens in year 6?
Oh, that's a great question.
Because business isn't static, it's incredibly dynamic. A structure that perfectly served a low-risk bootstrap startup in year 1 might become a massive bottleneck or a terrible tax burden as that success scales into year 6.
So the smartest entrepreneurs don't just treat their structure as a one-time form. They file and forget in a drawer.
Exactly. They view it as a living, evolving tool. It's a piece of strategic technology that has to be constantly evaluated, adapted, and sometimes completely overhauled.
You are building a foundation, but you have to make sure you can reinforce it as the building gets taller.
It's all about maintaining optionality while protecting your downside.
Well said. If you want to read more, check out our blog at intothemargins.com/playbook.
And if this deep dive helped clarify the complex mechanics of business structures, or, hey, if you have your own nightmare story about a partnership gone wrong, drop a comment below. We genuinely read all of them.
We really do, and it helps us figure out what to tackle next. Please do like, subscribe, and share this with anyone who's in the trenches of building a business right now.
We have plenty of other deep dives dissecting the mechanics of profitability, growth, and legal strategy waiting for you.
Thank you so much for spending your time with us today and for letting us be a small part of your entrepreneurial journey.
Keep building that invisible architecture. Keep protecting your downside, and we will catch you on the next deep dive.